Hi, everyone. Thanks for joining us today in what is our third Dentons Academy webinar. Today, we'll be discussing ethics in government contracting, and more specifically, the intersection between the model rules of professional conduct and conflicts of interest and the hiring of government officials. For those of you who have not yet had the pleasure to meet, my name is Tyler Thomas, and I'm a Senior Managing Associate in our Government Contracts Practice Group. And I'm pleased to be joined today by Joe Martinez, the Denver office managing partner and a partner in our Government Contracts Practice Group. Just a quick intro for Joe. His practice focuses on all aspects of government contract litigation and corporate counseling. And he's also a member of our political law, ethics, and disclosure team and counsels clients regarding federal, state, local election law, campaign and finance, ethical matters, and assists government contractors in navigating that intersection of law, politics, public policy. And I'm happy to have him joining me on this webinar today.
Thanks, happy to be here.
Also presenting with us today is Lisette Washington, a managing associate in our Government Contracts Practice Group. Lisette's practice also touches on all aspects of government contracting. And prior to joining us at Dentons, Lisette worked as a government contracts attorney for NASA. And we're grateful to have her insights today, and specifically on the rules applicable to former government officials. So Lisette, thanks for joining us as well.
Thank you, Tyler.
All right, so for those of you who are joining us for the first time, Dentons Academy is a series that we're rolling out this year to bring clients practical analysis of government contracts related issues. Our goal is to provide a mixture of substantive legal updates as well as practical advice, and we've tried to provide a mixture of the two thus far. Our first webinar summarized government contracts legal updates from 2020, and our second one provided more practical advice on cybersecurity, DIBCAC reviews, and TMMC. And if you missed either of those and would like to watch them or receive the materials, the recordings and materials are posted on our website, or you can reach out to me, and I'm happy to get you them. And so today we are covering ethics in government contracting, and we intend to provide at least one course each year that is going to be eligible for an ethics CLE credit. So on that note, and regarding CLE credit, the webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use your computer outside the webinar software, and it will prevent you from earning a CLE credit. One other important note is if you have a New York or New Jersey license, please be sure to listen for the code word that will be given during the program. And when prompted, you'll need to enter that code word into the Q&A section on the screen. And if you don't have a New York or New Jersey license, you don't have to worry about this. And then lastly, and prior to getting into the materials today, I wanted to note that we're planning to host at least 2 more webinars this year after a brief summer hiatus, and we'll be circulating those topics and an invitation in the coming weeks. All right, so the agenda today and all of the topics that will be discussed relate to the intersection of the model rules of professional conduct for lawyers with some of the ethical and compliance requirements placed on government contractors. Specifically, I'll be addressing the model rules of professional conduct, including those rules that address confidentiality of information and conflicts of interest. Lisette's then going to take us through the ethical and compliance requirements related to hiring former government employees, and Joe's going to close us out today with a discussion on OCIs. So if anyone from the audience happens to not be a lawyer, the portions of the discussion related to the model rules of professional conduct will be covered at depth at the beginning and continue to be referenced throughout. Those are less likely to be of importance to you, but we hope that the discussion related to OCIs and the rules around hiring former government employees will still prove valuable. So hope you hang on with us through the beginning of this webinar. We also set aside a little time for Q&As, and if you have any though, please feel free to reach out anytime during the webinar through the Q&A box, and I will try to work them into the topics being discussed. All right, so for those lawyers in the audience, you're very familiar with the model rules of professional conduct. We considered various routes on the discussion of the intersection of these rules with government contracting compliance requirements, such as the rules related to representing organizations, to advocating on behalf of clients, to the truthfulness in statements to others, but ultimately settled on focusing the discussion today on the rules of the conflicts of interest that apply to lawyers. So diving right in, the foundation for most of the conflict of interest rules and the model rules of professional conduct stem from Rule 1.6 on the confidentiality of information. There are essentially two requirements of this rule. First, to not reveal information relating to the representation of a client unless the client gives informed consent. And second, to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Now, but besides when the disclosure is implicitly authorized in order to carry out the representation, there are 7 exceptions to this general rule, and a few just to highlight quickly are that you're able to disclose the client communication if you're going to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, and in furtherance of which the client has used the lawyer's services. Another exception is to prevent, mitigate, rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. And potentially more relevant, to our discussion today is to comply with law or court order, or to detect and resolve conflicts of interest arising from the lawyer's change of employment. But on this last point, it's important to say that the disclosure is only permitted if the information revealed would not compromise the attorney-client privilege or otherwise prejudice the client. Again, we're primarily addressing this rule because the rules related to conflicts of interest build on this general rule that a lawyer is not going to reveal information related to the representation of a client unless that client gives informed consent. So that leads us to the next question, which is, what are the conflicts of interest rules that apply to lawyers? Well, there are 5 rules that address conflicts of interest. Rule 1.7 contains the fundamental rule that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest, but may represent a client if the representation is not a direct conflict, so the two clients, directly conflicting with another, and each affected client gives informed consent confirmed in writing, so you get a waiver. This obviously ties back to the general rule on confidentiality of information. Rule 1.8 walks through more particular rules related to entering into business transactions with a client, not using information relating to the representation of a client to the disadvantage of that client unless they give informed consent, rules related to gifts, literary or media rights, financial assistance, compensation, negotiating limitation of liability for representation, and the list goes on of the particular rules related to conflicts of interest. Rules 1.9 and 1.11 are going to be the focus of the next 2 slides, so I'm going to skip those for the time being. And then Rule 1.10 addresses how conflicts of interest rules apply to law firms, and really isn't that relevant to the discussion today, so I'm not going to get into that one. Okay, so Rule 1.9, duties to former clients. It contains considerations that will apply to lawyers moving from one government contractor to another, or from an outside law firm to a government contractor, and therefore, wanted to highlight this rule in particular for discussion today. As relevant, the rule provides that a lawyer who has formerly represented a client in a matter, or whose present or former firm has formerly represented a client in a matter, shall not thereafter use information relating to the representation to the disadvantage of the former client, except 1, as the rules would permit or require with respect to the client. So, for example, if the former client were to give informed consent, or if one of the exceptions to Rule 1.6 on confidentiality of information were to apply, or 2, when the information has become generally known or publicly available. This rule also provides that a lawyer may not reveal information relating to the representation, and similarly, an exception applies if the rules would permit or require revealing such information. So the specific connection of this rule to the rules that apply to government contractors related to OCIs and hiring government employees will be discussed a little bit and just a little bit by Lisette and Joe, but really wanted to highlight, that this rule and the duties to former clients does have relevance and analogies in the rule related to OCIs and hiring former government employees. I also wanted to note that this rule covers various other duties that lawyers have to former clients, including that a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter if that new person's interests are directly or materially adverse to the interests of the former client. Again, the standing exception for unless the former client gives informed consent confirmed in writing. There are also rules specific to law firms that, again, aren't really relevant to our discussion today. The last rule that I wanted to cover before we kind of shift into the regulations and rules and statutes that apply to government contractors for the hiring of former employees and OCIs is Rule 1.11, which addresses special conflicts of interest of former and current government officers and employees. So this rule provides that a lawyer who has formerly served as a public officer or employee of the government is subject to Rule 1.9, just discussed on the prior slide. And as a quick recap, just means they won't use or reveal that information relating to the representation to the disadvantage of that former client, unless an exception applies. But this rule also adds, first, that the former government employee may not work on a matter in which the lawyer participated personally and substantially as a public officer or employee, unless the appropriate government agency gives its informed consent confirmed in writing to the representation. Second, that a lawyer shall not disclose what is called confidential government information and should not work on a matter in which information could be used to the material disadvantage of that entity. So confidential government information is information that has been obtained under government authority and which the government is prohibited by law from disclosing to the public or has legal privilege not to disclose and which is not otherwise available to the public. As an example of information that the government is prohibited by law from disclosing to the public is contractor proprietary information subject to 18 U.S.C. 1905. So most of you are probably familiar with that. That would apply to this rule. If such information is at play in the course of employment, then it's important to ensure that the lawyer is timely screened from any participation in the matter and a written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with the provisions of this rule, of Rule 1.11. So the idea of screening a lawyer is notably similar to one approach to mitigate OCIs, and Joe's going to discuss that mitigation technique. And it's also similar to the rules relating to engaging non-lawyer government officials, which Lissette's just about to address. And through the remainder of the slides today, you will notice there's purple font that is highlighting where each of these rules have similarity to the rules that apply when a government contractor is hiring a former government employee or to OCIs. The final thing I wanted to mention is that the rules on this slide also apply in the reverse scenario. So they apply to a lawyer who previously was employed as a government contractor and switches to government employment. With that, I'm going to turn it over to Lissette to now shift us into the discussion of the statutes, regulations, and rules applicable to employees leaving government employment and to government contractors hiring government employees.
Sure. Thanks, Tyler. Go to the next slide, please.
Of course.
Awesome. Okay. So as we all know, there's several rules and regulations with ethical implications. Look no further, for example, to FAR Part 3 on business practices, FAR Part 9 on contractor qualifications. But what we're focused on today in the context of the model rules Tyler just discussed are those rules and regulations that are relevant to hiring and compensating former government employees. So that with that short introduction, we're going to move straight to the key federal statute, which provides the post-employment restrictions for former government employees. That's 18 U.S.C. 207. Because this statute exists under Title 18, which is the main criminal the main criminal code for the U.S. government, we know there's criminal sanctions here for noncompliance. It doesn't apply only to attorneys, but it does overlay with Model Rules 1.9 and 1.11, which respectively provide the lawyer may not use information relating to the representation to the disadvantage of the former client, as Tyler mentioned, the former client being the federal government and the federal government agency, and the lawyer not working on a matter in which they participated personally and substantially as a government employee. So that leads us to the first main prohibition under 18 U.S.C. 207, formally titled Permanent Restrictions on Representation on Particular Matters, but we more commonly refer to it as the lifetime ban, which prohibits former government employees from knowingly making with an intent to influence any communication or any appearance before the government on a particular matter involving specific parties in which that person participated personally and substantially. So that is a lot. But essentially, the lawyer is not working on the same matters that they worked on the government side, where they participated. They had influence, gave advice, participated substantially. The rule requires that that matter involve specific parties, but it'd be prudent to look at the rule aside from the specific party requirement. For the reasons Tyler mentioned, the lawyer may have had access to confidential government information as they are advising, participating personally and substantially in that matter. And because we're dealing with litigation, business transactions, contracts, subcontracts, task and delivery orders, the nature of the matter, the nature of the involvement and parties requires a fact-specific assessment, right? So it really depends on the facts of the particular case, the particular matter, the nature of that involvement. One important note about Model Rule 1.11 is there is a carved exception that Tyler mentioned where the agency can provide informed consent in writing for the lawyer's representation in the matter. However, it's important to note that exception does not exist in 18 U.S.C. 207. So that's important to note. You may want to view this rule as not having an exception for that reason. While provided by the model rule, our criminal statute is simply saying do not participate, do not work on the matter that you participated substantially and personally with specific parties. So moving on to the next prohibition you see here, this 2-year restriction. There's a two-year restriction on former government employees who knowingly make with the intent to influence any communication to or appearance to the federal government in connection with a particular matter involving specific parties, which that person knew or reasonably should have known was actually pending under his or her official responsibility, right? So the major difference between this restriction and the last restriction is there is no element for that personal and substantial participation. It's simply the fact that that matter was pending under that person's official responsibility as they were a government employee. So we're most concerned about this when we're dealing with agency heads, for example, members of the Senior Executive Service, the SES, or anyone who's managing direct reports. Less concerned, for example, when you have a GS-15 who has a non-supervisory role, for example. So moving on to this next prohibition, which we refer to as the cooling off restriction or prohibition, there is a 1-year restriction on former government employees from knowingly making with an intent to influence any communication to or appearance before an officer or employee of the home agency. So that's the department or the agency in which that person served within 1 year. All right, so this applies to senior personnel, and the rules provide the conditions for their rates of pay and their position, but generally we're talking to very senior senior government personnel. And so it's prudent in this case that we treat all former government employees the same under this rule. We want them to cool off, not necessarily make any representations with the intent to influence back to their home agency. All right, more important for the senior executives, right, that have more influence, had more influence in those roles, but generally, you don't want folks going back to the home agency, right, where they know people, they know information, they know points of contact, they know a lot of information that the public would not know about how that agency operates. So you want them to cool off for 1 year. So the difference between this rule and the last prohibition for which this person is seeking official action is it did not need to be, you did not need to, again, participate personally and substantially. The fact of the matter is you're going back to a home agency as a senior executive seeking to influence and obtain official agency action. All right, so these are the top 3 prohibitions you want to know: the lifetime ban, the 2-year restriction, and the 1-year cooling off. Next slide, please. So these prohibitions are promulgated in 5 CFR Part 2641. So you'll see the prohibitions just discussed in this regulatory scheme as well. Skipping down to the cooling off period, the 2-year. Skipping down, there is a 2-year restriction, which essentially is extending cooling off period for very senior personnel, communicating to other very senior personnel. And so this gets a little bit complicated, right? Who's the very senior personnel that we're talking about? The rules provide what level of the executive service, right? Generally, there's 5 levels that we're talking about. We're talking about cabinet members. All the way at the top, you were talking about agency heads. We're talking about the chief counsel, chief scientists, folks in some very high level roles. So as a practical tip, it's best to incorporate these rules, the general rule, and then consider the exceptions on a case-by-case analysis, right? Instead of incorporating and considering the exceptions at the outset. Easiest to incorporate the general rules in your policies and procedures and then see where you might need to consider an exception. The regulatory scheme here also provides that in addition to other remedies provided by law, DOJ may void or rescind contracts or transactions or other obligations of the government in the event of a final conviction pursuant to 18 U.S.C. 207, right? So not desirable, not something that we want. It's important that former government employees understand what these prohibitions, what these restrictions are, but also important that contractors understand these as well, because there are cases where these actions are reviewed by the suspension and debarment official. All right, so even though these restrictions pertain specifically to that former government employee, the SDL, in reviewing present responsibility, may want to know about the contractor's policies and procedures. Are they adequate to prevent these types of situations from happening? So may send an RFI, for example. There is a specific individual that's being reviewed for present responsibility under Part 9, but the government may also be interested in the contractor's present responsibility under Part 9 as well. And so that goes back to the overarching policy of the government to only do business with responsible contractors. Next slide, please. Thank you. All right, so now we're going to shift a little bit to compensating former government employees. Another key statute, 41 U.S.C. 2104, regarding the prohibition of former government officials' acceptance of compensation from a contractor within 1 year of very specific activities listed here, contract related. The key threshold that we're looking at is $10 million. And so the rule is that the former government employee may not accept compensation from the contractor within 1 year of these following circumstances where they are working on the contractor's contract, right? So they're working in, for example, a procurement shop, right? Contracting office, serving as a program manager, deputy program manager, or ACO when that contractor received an award over 10 million, or that person awarded, modified, executed a contract or contract action over 10 million for that contractor, or they established rates on any of the contracts for that contractor valued over 10 million, or they approved contract payments in excess of 10 million. And lastly, or if they paid or settled a claim in excess of 10 million, right? So we have this $10 million threshold that we're looking at. There is an exception built into this statute that former government employees are not prohibited from accepting compensation from a division or an affiliate of the contractor that doesn't produce the same or similar products or services as the entity responsible for the contract. All right, so the statute essentially is allowing for a situation where someone in the procurement shop, someone who's the PM, deputy PM, ACO could be hired, but simply would be walled off from that division or that affiliate that is performing or working under the contract that they touched less than 1 year ago, right? So this hits on Model Rule 1.8 pertaining to business transactions, right? Prohibiting accepting compensation from one client for representing another client, right? So something to note is, in the procurement shop, you may have, folks that are contracting officers, contract specialists. Some of those people do have licenses to practice law, even though they are not practicing for the agency, right? So need to be mindful of these model rules. You don't want the appearance of a conflict of interest or the appearance that the government employee has placed their personal interest above the best interest of their client, the federal government, for another party, that is the contractor, right? You don't want the appearance that there's compensation, that compensation that eventually went to that former government employee interfered with their independence or their professional judgment as they were executing those contract actions, right? So prudent to be conservative on this rule. For example, you may have a contract action at issue 9.9 million, right? So it doesn't necessarily hit that 10 million threshold. Right? It's probably easiest here, right, to let everyone, right, who came out of that procurement shop or who worked on your contract actions to cool off for that 1 year period, right? The rule specifically provides for prohibition for specific individuals, right? But if you are leaning a little more on the conservative side, you're applying this rule generally, right? Generally to your government employees, right, to cool off for 1 year. And similar to 18, I'm sorry, Tyler, just one last point. Similar to 18 USC, there are criminal, civil penalties, administrative penalties. Administrative action, for the most part, refers to suspension and debarment, where you're reviewing present responsibility. Next slide, please. All right, so this last prohibition we are going to cover is the prohibition on compensating former DoD officials. All right, so it's a DFARS 252-203-7000. As you see here, the contractor must not knowingly provide compensation to a covered DoD official within 2 years after that DoD official leaves government service without first determining that official has sought and received or has not received after 30 days of seeking a written opinion from the DoD ethics counselor as to the applicability of the post-employment restrictions. That's what we previously discussed, 18 USC 207, or the regulatory scheme 5 CFR Part 2641, right, to the activities anticipated for their post-employment, right? So we're talking here about very senior executives and government employees who worked in the acquisition shop, as indicated on the last slide, and who participated personally and substantially in acquisition over $10 million, right? So this specific prohibition requires a certification, a representation, and it is required for all solicitations, including FAR Part 12 commercial item contracts and solicitations for task and delivery orders. Right? And so the contractor is representing that all covered DoD officials, right? Those who are specifically covered are mentioned in the regulation, are in compliance with the post-employment restrictions previously mentioned. So that is the lifetime ban, right? That is the 2-year restriction for matters under your official responsibility. That is the cooling off period for going back to your home agency. That is the 2-year cooling off period for our very senior government employees. Again, all of those who qualifies specifically mentioned in the regulations. So to be prudent here, you want all of your your former government employees, not just your DoD officials, to seek an ethics opinion before they leave government service. Usually there's a checklist before they turn in their badge. One of those items on that checklist is ethics counseling, and you just want to be sure that that person did that ethics counseling, right? And they are essentially sitting down with ethics expert covering the activities that they participated in as a government official and the types of activities that they may be participating in with the contractor, and having someone analyze and apply those post-employment restrictions. Right, so you want that for all your government employees. This specific certification is for DoD, but the policies and procedures should reflect that that is the case for government employees from any agency, any department. And here we see also there is a risk for noncompliance, contract rescission, suspension of debarment, as we mentioned before, for failure to comply here. So next slide, please.
Sorry, I was talking on mute. There's a few questions on this slide that I think makes sense to discuss here. Sure. The first is if there's a disagreement on the scope of the government's ethics letter, is there an appeals process? For example, the ethics letter is overly broad per the particular matter, but the government attorney disagrees.
I have not heard of any appeals process, and the ethics letter essentially is providing guidance, right? So you'll see several sources mentioning that the ethics letter is not clearance, not a bar to liability, right? DOJ is going to consider good faith reliance on that ethics letter, but what's important to give to the ethics advisor is the most detailed factual information possible for the ethics counselor to give that guidance. Now, the reason it might be broad is the ethics advisor doesn't have or doesn't feel as if they have all of the factual information they need, so they're pointing to general prohibitions, right? All of these require fact-specific inquiries, right? So they're not sitting right in the division. They're not sitting in the contractor's facility. They don't know the specific nature of the activities that are going on, right? So sometimes I'd agree that sometimes the ethics letters are broad, right? And putting the onus essentially on the contractor, the employee, to understand what these rules are. Not having seen any appeals process to answer the question. And then also on the next slide, there's a point that this ethics letter that we get, it's helpful, it's useful, good faith reliance is considered, but will not serve as a bar for criminal liability or civil penalties.
Thanks. And the next question, I guess, before we hop to this last slide, is under the Procurement Integrity Act prohibition on accepting compensation for certain personnel, does it apply to all legal entities of a parent organization, or specifically to the legal entity that participated in the procurement that's subject to the Procurement Integrity Act?
All right, can we go back to that slide really quickly?
Yeah, of course.
So the way the rule reads, can you go back one more?
Mm-hmm.
So I'd say the latter, specifically because this statute is carving out an exception, right, to allow for that former government official to work in a division or an affiliate that doesn't involve this contract, right? So essentially, there might be some walling off between the entities. It's interesting that the statute says division, right? So creating a separation between divisions under the same legal entity could be complicated. And so here it'd be prudent to look at this rule without the exception. Looking at the exception, I think, makes it a little bit complicated, right? Which division is sufficiently removed from the contract? Or, what if that division eventually becomes involved, right, in the contract, right? So here it seems that, the general rule to not provide the compensation, right? Only use that exception if you absolutely have to use that exception and get that contracting officer, that contract person who was in the shop working on actions over 10 million into your company. But here it seems that the 1 year period, I'd let that go. That's my view in order to avoid, risk of these tricky situations.
Great, thanks.
Awesome.
All right.
So hopefully that's good. Happy to follow up on any of these questions if needed. And here, best practices. I've covered these a little bit. Observe and comply with, of course, the model rules, most important for attorneys, all right, for professional obligations, as well as the applicable post-employment restrictions that we've discussed. 18 USC 207 is key. Notify your employer, right, if you're a former government employee, when a task, assignment, or activity might raise an ethics issue, right, hadn't been thought out at the outset, right, but it comes up afterwards. There are some exceptions, right, to deal with, to analyze, perhaps go back to, as we mentioned, the applicable ethics advisor, give them the facts and circumstances that they need to give guidance. When in doubt, contact that ethics advisor. They do give guidance to former government employees, folks that are no longer working in government service. But again, we know this letter, this clearance from ethics is not a bar to liability. Someone may still, unfortunately, right, have conviction under 18 USC 207, unfortunately may be reviewed for present responsibility under bar part 9 by the SDL, right? And contractor employers, right? So you want to do an in-depth screening of your former government employees, right? That means you want to know what their activities were, not only the agency from which they just came, right? But any government agencies. Remember the lifetime ban, right? Our top prohibition. The lifetime prohibition from participating in anything where you participated personally or substantially, right, with specific parties. So that's important that you go back to where that person worked. Any government agency, you want to know that information, what they were working on, particularly for the senior officials, right? Because the statutes consider influence, right? And so that's why we're focused on folks that were in positions of influence, right? So you're building a firewall, as we discuss, for matters and transactions where the government employees cannot, and then when we're leaning more conservative, should not be involved. And then conducting compliance checks for the certification made for compensating DoD employees. Again, we want an ethics opinion. We want former government employees to seek an ethics opinion before they leave government service. And then when specific circumstances come up, we want them to seek guidance for those particular activities as well. And then, of course, you want to ensure that your policies, procedures, and practices align with the rules and restrictions. Most important are the general rules, right? Because these rules can get a little tricky, right? So you want to ensure that the general prohibition, the general restriction is reflected, and that there is a process, if needed, to address exceptions. So that's what I have on this section. Over to you, Joe.
All right, before Joe gets started, as I mentioned at the beginning of the webinar, we need to take a brief moment to satisfy the CLE requirements by delivering the following code word. All New York and New Jersey licensed attendees must type the code word compliance in the Q&A section on the right-hand side of your WebEx screen. Make sure you hit the send button so that it registers. In case you missed it the first time, the code word is compliance. And Joe, will you walk us through the OCIs?
Sure. So the next section that we're going to be talking about are organizational conflicts of interest, and we can move to the next slide. Organizational conflicts of interest, a little bit different than what we've been talking about so far, in that our focus is now changing to the entity itself and not the specific employees. So now we're a little broader aperture to talk about things that a company might do that would create conflicts of interest. Of course, recognizing companies are made up of their employees and do things through their employees. So there's still that intersection, but a little change in focus. And starting off, the government's policy, and as I think consistent with all the things we've been talking about, factor into this overall policy of, in the procurement process, wanting to ensure an open and fair process as much as possible. And again, certainly when you're doing a competitive acquisition, that you want fair ground rules, you want a fair process, and you don't want there to be conflicts of interest. So just as Lisette was talking about, at least focused for contractors, many of those post-employment restrictions are intended to continue this policy of not having someone with all the inside information from the agency basically switch sides and now help one particular contractor to the detriment of others. Same thing is going to be true here with the organizational conflicts of interest. So all of this is built around how do we maintain a fair acquisition system as much as possible. Organizational conflicts of interest come up quite often. We're going to walk through what those look like and how to address them. A critical factor is how much do you have to prove an organizational conflict of interest? And that really stems from a fact that, on the one hand, the government strives to avoid the appearance of improprieties. So even if information is not actually shared, but there was an opportunity to do it, it wants the system to be fair, but also recognizing that in a protest environment, any unhappy competitor can throw around allegations of OCI. So when we're talking about an OCI, it really required hard facts and specific evidence about where the organizational conflict of interest might occur. Again, because we're focused on the organization, the real underpinning for OCI rules are preventing a bias in the procurement system, which we'll talk about and I think will make more sense when we step through some of the examples, as well as preventing unfair competitive advantages. So again, really going back to that foundational motive of ensuring that the system is as fair as possible. When a organizational conflict of interest potential arises, contracting officers are required to analyze whether the acquisition might have an opportunity for a conflict of interest. For those of you who work in the proposal preparation side of government contracting, you're likely aware that in the submission of proposals, contractors themselves are asked to identify if they're aware of any potential organizational conflict of interest, or maybe phrased differently, how they've assured there isn't an organizational conflict of interest that would preclude them from submitting their proposal. So a little bit of a shift to place that onus on contractors, but goes to this point that the idea is to identify very early on, are there organizational conflicts of interest, or at least the potential for organizational conflicts of interest, and then to figure out, are there ways that those can be mitigated? And so again, just kind of picking on the theme that we've talked about under the model rules, as well as the post-employment restrictions, each of those have different ways of providing for restrictions. So a government employee who switches from government service to work for a contractor might create the opportunity for an organizational conflict of interest, but then you have some of those additional safeguards that are in place that, if they're being complied with, would mitigate that OCI. So focus on identifying them early, figuring out, is there a way to mitigate them? And I think another critical point, and we haven't delved into specific conflicts of interest on the procurement side. I think we've covered them generally for lawyers, in part to make sure you all get your coveted ethics credit. We have to kind of hew back to those model rules. But you have the personal conflict of interest, certainly for the lawyer in his or her service as the lawyer. There are additional personal conflicts of interest. So things like, my spouse works for the agency that we're submitting this proposal to, or I'm a government employee and I own stock or have financial interests in a particular outcome. Those are a little bit different. Didn't fit within our hour here, but it's important to contrast that. Again, organizational conflicts of interest, as we'll see when we walk through the types of them, are really focused on just the intersection of the kind of work the contractor has done before or might do in the future, and not any particular impropriety or personal conflict of interest of an employee. So if we could move to the next slide. Generally, organizational conflicts of interest fall within three broad categories. The FAR is careful to admonish that this is not the end-all be-all. There are other iterations or ways that these might arise, but the basic kind of concept of an organizational conflict of interest is, has the contractor or contractor through its employees been involved in this or a similar procurement in some way that would render it unfair for that contractor now to submit an offer? And so the very kind of typical, though we'll talk about some other permutations of this, is if the government needed to go out to industry and say, we know we need a new IT infrastructure. We're exploring cloud computing. We need new desktops and laptops, and we want a new kind of ecosystem for information technology. The agency may determine that inside the agency doesn't have the expertise on exactly what that should look like. So it goes out to industry and it hires a contractor to act as a consultant, to come in and assess where the agency is, what its needs are, and what a new information technology system might look like. It would then be problematic for that same company to turn around and submit the bid and say, hey, I know exactly what you need. I helped you decide what those requirements are. It would be unfair in a variety of ways for that entity to now compete for that same work. And though that unfairness falls within one of three, and it could be multiple, of these broad categories. The first might be unequal access to information. I might learn things in my role as the consultant from the agency as to what exactly its needs are, things on its wish list. So these are minimal requirements, what its other priorities might be, things that are proprietary source information to the government that it hasn't disclosed in its general requirements documents. I might know, especially in a best value trade-off kind of environment, that, while this is the minimal requirement, the government would really like to have these additional services or prioritizes these trade-offs more. I know that because I've talked to these people, so I have unequal access to information in that process. Some of that unequal access to information may come from, I reviewed source selection. I reviewed some of the proposals before I switched and became employed with a contractor. We have our purple highlighting here to note that is going to start dovetailing with some of the other requirements under either the model rules of professional conduct or some of the post-employment rules Lisette was talking about, where you might be able to mitigate this. And we're going to talk mitigation a little bit further in a moment, by taking me out of the responsibility. So you can firewall me off if I have unequal access to information. Taking some individual employees out of the mix might be able to mitigate that one. So compliance with the other rules that we've talked about might help resolve unequal access to information, but that's only one of the type of concerns. The second would be impaired objectivity. If a entity knew that it could both help the government identify what its needs are and what its, in this example, what its IT infrastructure ought to look like, there's a risk, and then subsequently bid on that work, there's a risk that the contractor is not going to be objective when providing its example. When it says, you know, a competitor's product or an approach that my company doesn't have actually might be a better fit for you, rather than telling the agency that, there's an inherent risk, whether conscious or subconsciously, that the contractor won't take that approach and will be influenced by its own offerings. And so if you set up rules that prevent that from occurring, you're helping ensure that you're getting purely objective analysis, because that entity knows it's not going to be able to compete for the actual procurement of the materials at a later date. So it can just be fully candid in doing that. And a slight permutation of that are biased ground rules, where I might give you objective requirements, but when we write the ground rules for the procurement, I suggest we do them in a way that is favorable to my company. So if I know one of my strengths is in a particular type of technology, I might suggest that you should weight that higher than other areas where my company might be weaker. So those are the ways that an involvement with the government at the outset can create any of these general three types. And again, we're going to talk, there are other permutations of it, but these are the ways in which organizational conflicts of interest arise. So if we could move to the next slide. The common scenario. So the first one I gave you is this advising government on needs, future procurements. That is kind of the black letter, archetype of an OCI. But there are others, and it's in these other scenarios where things get a little bit more complicated. A big one are mergers and acquisitions. As many of us may be aware just from following the industry, there's been a lot of consolidation in government contracting. So my company may not do that advising work. We have a great OCI policy. We don't do any of the advising. We only do the providing of the materials. So we think we're free and clear, but lo and behold, we merge with another company who does do that work and happen to do that work for an upcoming acquisition we want to compete on. We're now going to have a potential OCI. Same kind of issue arises when you have technical data being provided. If you're providing testing equipment, really anytime there's an opportunity for a contractor to influence the rules of the road that might impact a future procurement, you're going to have a potential OCI, or when you have information coming from another source. So two big ones, again, dovetailing on what Lisette was talking about, hiring former government professionals. Now I know the rules of the road because I've hired someone who wrote them. I wasn't retained to do that as a contractor for the government, but I've reached the same result because I've hired a former government employee. So again, many of the rules that Lisette was talking about, some of the underpinning of them, for there are a variety of reasons why those rules exist, but one of them is that cooling off period is to prevent this from happening. Though the hiring of a former procurement official, a lot of those rules are whether that official can go back and deal with the agency. This is more focused on whether there's information in that individual's head that could be shared. So they may not ever talk to the agency again, but they're talking to their colleagues at the new company and can say, I know exactly what they need. I helped write those requirements. So those are circumstances where you can have a springing OCI come up because you've acquired a company, hired former personnel. Same result can occur when you hire former employees of one of your competitors. There are some mixed decisions as to whether those create OCIs versus other private rights of action around trade secrets, enforcement of non-disclosure agreements. So when you're talking non-government officials, competitors, employees, it opens up into a variety of other ways that can be managed. But again, you are gathering information that might be unfair because now you know what your competitor was doing because you've hired one of their former personnel. So all different scenarios in which OCI, or at least potential OCI, might arise. And if we could move to the next slide. So consequences of OCI, to be brief here, not winning the contract. If you make misstatements about your eligibility, saying there are no OCIs when there are, certainly could create a breach of contract, False Claims Act liability, a number of ways that you could be penalized for not properly disclosing an OCI. Bid protests are where we see the primary enforcement mechanism. So competitors say, hey, that they hired this government employee and we know that, and we think that creates an OCI, and that gets adjudicated through the bid protest process. So the ultimate consequence is either not winning the work or winning the work but having other negative legal consequences. And of course, for lawyers, regulated by the rules of professional conduct, if you violated the confidences of your client at your prior client by moving from government to industry, certainly could face disciplinary action. And again, Lisette identified many of the criminal sanctions that could come from not complying with the other post-employment restrictions, but general kind of overview of those consequences. And then quickly, I know we're butting up against the time. I don't know if we had any additional questions, but we're going to do our best to get those answered. How can they be mitigated? Unequal access to information is probably the easiest that is open to mitigation, meaning say, yes, we hired this person. They had information about it. We know that. Here's what we're going to do. That person's not going to work on this procurement. They're not going to have access to the team that's working on this procurement. They won't have access to any of the materials. They've been admonished not to discuss this with anybody. We can basically firewall them off from the ongoing acquisition or our preparation of our bid, and therefore there is no mitigation. Or again, especially when information coming from the government might be at issue. Okay, yes, we know some things because of the circumstance, but you can also mitigate it by making a disclosure of those things we know. So if we're aware of some prioritization within the agency of certain things it wants out of a procurement, one way to mitigate that is tell everybody. Maybe make it a little bit more open and identify those as your preferred list of requirements. And then we're all on the even footing. So those are ways to mitigate unequal access to information. And again, tying back for the ethics credit, kind of falls in with some of the strategies that need to be used for conflicts generally, which is to firewall individuals off when that can be done. For the others, we could move to the other slides. Much harder to mitigate because there's sort of this implied, the right hand doesn't need to know what the left hand is doing. If I'm on a team helping the government write the ground rules for an acquisition, even if I never share information with my colleagues back at the office, I know what my company does. I know the kind of work, I know where our strengths and weaknesses might exist. I don't have to coordinate or share that information. I can just write the rules for it. Some ways in which you can mitigate. So it's not impossible, it's just hard because it's this implicit kind of built-in bias into the system. Some ways to do it are to say, we helped draft this particular part of the work. We won't compete for that. We'll have a subcontractor who we won't share any information with. We didn't know that subcontractor. We couldn't have steered it to them. That subcontractor will bid with us, and that may help mitigate it. Ultimately, the audience here you're convincing is the government contracting officer that here's the OCI or potential OCI, here's what we're mitigating, and whether it's effective. If the government concurs that you have mitigated it, then it makes it much harder. Not impossible, but harder for a competitor to challenge it. They'd have to show that the government was highly unreasonable in its adoption. There are some cases that basically say, as long as they acknowledged it and mitigated it, there's really little more that you can protest. Some wiggle room kind of around that, arguably, but the ultimate audience trying to convince the contracting officer, here's what we did to avoid the ability for this bias ground rule. Kind of OCI trends, again, I know we're just bumping up against the hour here, seeing more OCI issues predominantly because there is some consolidation, as you said, inside the industry. So that has, by consolidating now, there are fewer options to go to, so more opportunity for the same entity to be asked to look at requirements and then perform the work. Also, some view that with that consolidation and bigger awards, that it's more competitive. So more opportunity to protest. If I'm unhappy with the way a procurement is going or unhappy with the decision, I may throw the flag and try and protest to turn the award, and policing the OCI issue through the protest process. So as competition increases for fewer awards, you'll see again increasing OCI issues. So with that, I know again we're just a minute over, but happy to see if anyone would like to hang on to address questions, or I don't know, Tyler, if you thank you all for joining. We hope this is very valuable and helpful to everyone. And